Like I'm sure everyone else, I'm obviously paying a lot of attention to what's happening with the polling and with the dynamics in Joe Biden's campaign, growing numbers of Democrats calling for him to withdraw and make way for somebody else, and then growing intransigence on the part of the president and his campaign. And I am not going to revisit all of this. We've spent, in a sense, a couple weeks talking about this. I will just point out that I don't see anything so far fundamentally altering the dynamics of this race as they set in the aftermath of the disappointing appearance of Joe Biden, the disappointing performance in the presidential debate of a couple of weeks ago now. It does appear perhaps
But
he's hit a floor in terms
Bernie,
of the way in which he's declining. Is somebody trying to ask a
yeah,
question?
I'm trying to say Bernie Sanders just announced that we should support Biden.
I did see the headline. I did not see the article. As in, I haven't read what Bernie Sanders has to say yet. And look, there was apparently a quite strong performance at a rally in Detroit yesterday. People saying this is a Biden they haven't seen since maybe it was the vice president under Barack Obama. Having said that, I will just, indicate and what I've tried to say for the last couple of weeks, which is to counsel a kind of realism. That for those of us who are fans of Joe Biden, supporters of Joe Biden, really tuned into the news, we noticed that a energetic Joe Biden showed up at a Detroit high school yesterday. For the voters that Biden actually has to carry to win this election, they did apparently, many of them, tune in to the press conference this Thursday night. And the press conference showed a more competent Joe Biden, although there were some really unfortunate lapses, right? Referring to Kamala Harris as Donald Trump, or Vice President Trump referring to Vladimir Zelensky as Putin. But having said that, he did appear more capable of answering, in particular, rather tangled foreign policy questions in a very detailed and generally convincing way. But I just want to emphasize, right, that the impression created by the debate and the way in which it reinforced a suspicion or a conviction of a large portion of the American people that Joe Biden is simply too old to effectively serve as president for another 4 years. I think of that impression as, at this point, at least, quite indelible. And so I don't know what Joe Biden can do to reverse it. Perhaps a performance in a subsequent debate, perhaps a very strong performance at the convention. But please note that as much as the supporters of Biden are going to be looking for evidence that the old Joe is back, and that there's a fighting, fiery candidate, the people who are skeptical are going to be looking for evidence that he's not up to the job. And I'm not confident that he won't provide them lots of that evidence over the next 4 months if they're looking for it. So, having said all of that, I'm proposing that we pivot away from the election and into what I suggested last week was the other really consequential thing that has been happening in American politics, and in many ways has perhaps been eclipsed by our focus on the presidential campaign. But we have now concluded a Supreme Court term. It's the third term under the very conservative supermajority that was consolidated by Donald Trump's three appointments to the bench, to the court. And I think that what we're seeing, and I want to be as clear as possible about this, is a fundamental reconstitution of the branches of the federal government, a shift of power away from Congress and into the presidency and the judiciary, and at the same time, a reining in of the administrative state, that this is fundamentally altering both the balance of power between the branches of government and the modus operandi, the way that the branches of government actually are able to operate, and that the consequence is that we may have a fundamentally different structure of government for, and then I don't know how long, the next 20, 30, 50 years. And so, as much as we worry that one possible outcome of the presidential election is that a candidate who may be fatal to American democracy will be elected, another thing that we should be paying attention to is that the Supreme Court is in many ways enabling Donald Trump to be a much less restrained, much more powerful, strong man leader, but not just that, that the Supreme Court is in so many areas, whether it's with regards to voting rights or with regards to congressional districting and how our elections are conducted, obviously with regards to guns and abortion, but also fundamentally with regards to executive power and accountability, changing the fundamental dynamics of American politics. And so that's where I want to concentrate today. It may take more than a session to go through this. This was a Supreme Court session with an awful lot of important issues. I have here a bad cartoon meant to be Samuel Alito saying there's no reason he should recuse himself, having flown his flags. We know that Clarence Thomas's wife was sending emails supporting the people trying to overturn the outcome of the 2020 election. And one of the things I want to address today is the legitimacy of the Supreme Court, or I should say the waning legitimacy of the Supreme Court, the growing perception on the part of large portions of Americans that this is a partisan institution. Obviously, Democrats are particularly dissatisfied with the Republican appointed supermajority on the Supreme Court, but Republicans also recognize the pattern of voting, and the pattern of voting is one in which it appears for at least the last 75 years, we have the highest rate of pure partisan splits on this court. It makes the court appear to be another partisan branch of government. And then the question arises, why should we have a partisan branch of government with no electoral accountability? That doesn't seem right. So the very justification for lifelong appointments to the court seems to be undermined by the conduct of the current court. Justice must not only be done, it must be seen to be done. And frankly, the way in which some of the justices are conducting themselves does not allow them to maintain the appearance of impartiality, of being non-political, that the court has worked so hard over centuries to maintain. Chief Justice Marshall, in one of his letters, describes it as catastrophic for the court to appear to be part of the ordinary politics of our society. That seems to be increasingly inescapably the conclusion that most Americans are reaching. I have on the board the cartoon I've used before, right? Which amendment protects us from the Supreme Court? And the obvious answer to that is there is no amendment. If we want to see the decision in Donald J. Trump versus the United States that essentially exempts the most powerful person in our federal government from accountability for violating the laws, if we want to see that decision overturned, the Supreme Court has to be reconstituted. The justices who pass that decision have to be removed, they have to retire, they have to resign, they have to die, and be replaced with other justices who regard that as a fundamental mistake and seek at the nearest opportunity to overturn it. The same thing with the Dobbs decision, the same thing with other decisions that I will speak with you about today. The only way to revisit these decisions in the 21st century appears to be to remake the court. I have here, right, the old image of January 6th, 2020, the breach of the Capitol, the march of Trump supporters in, the chaos, the anarchy, as a reminder of what it is the Supreme Court has essentially immunized the president against, not necessarily via the standard articulated in their decision, but via the considerable delay that they've brought about in Donald Trump's facing a court of law for accountability. Please note that right in January of 2024, Jack Smith's office asked the Supreme Court to hear this on an expedited basis. Not only did they refuse when it was so obvious that it would be appealed to the Supreme Court, there was no reason not to treat it on an expedited basis, except for the delay that it would create. They then issued their decision on the last day of their session, July 1st, which is very late in the calendar for a Supreme Court decision to be announced. Again, it appears that the court is doing its best to put its finger on the scale of a presidential election by exempting one of the candidates from legal accountability for his alleged criminality. And so then I have two images in the corners, again, images we've looked at before. And one is the image of the Supreme Court that I encountered as I studied civics classes in high school, when I went to college and took constitutional law in graduate school, when I discovered and fell in love with the philosophy of law, jurisprudence. The image of a hallowed temple of law, right? The idea that we do not have any official religion, any established religion in the society, but we have a civil religion, which says that we put the rule of law above the rule of men. All men are accountable to the rules of our society as they are expressed in our Constitution, and our Constitution, as flawed and imperfect a document as it was, as originally a slave charter, also contained within it the institutions and mechanisms, the promises of freedom and liberty and equality for all that eventually allowed us to repair some of its deepest flaws, that generated a kind of progressive dynamic to our society. Slow, uneven, unsteady progress, but real progress nevertheless. And that image of the court, which I think it was pretty easy to sustain and to maintain as part of the narrative identity that we collectively construct of ourselves in part of fashioning our cohesion as a society, that account of why we have 9 people in robes, 9 rulers in robes, who are doing the work of maintaining our collective fidelity to the Constitution. I think it's really hard to maintain that understanding of what the court does in the 21st century. So the cartoon image of this, right, decrepit, uh, decaying institution, abandoned, right? In previous versions of these slides, I've had the court being barricaded to protect it from the protesters. But I particularly like the imagery of the idea of the court as a haunted house, haunted by ideas that we thought we had exorcised from American politics 50 or 100 years ago, that now rise from the dead, and not just ghost like, they're actually reanimated in the decisions of this court, come back to life in order to take us backwards. And so the idea that there's a slow motion constitutional coup that is accelerating. I want to be as clear as possible at the outset about this. I believe this court is trying to move us backwards in time to a era of constitutional law in which much of the progressive narrative that the middle of the 20th century sustained is revoked, overturned, upended, and that it has the power to do this. And as it does it, it fundamentally remakes the law, the politics, the nature of our society. So that's the focus, and that's a way of introducing this term in the court. And I want to suggest that 2324 may be the most consequential term in several generations. And when I say that, I have a question mark here because, of course, we don't know the exact implications of the Trump v. US case or the Relentless v. Commerce case. The cases that seem to be so significant will have to wait for lower courts to begin interpreting and adjudicating them, for the Supreme Court to come back and work out some of the things that are currently a little hard to discern. But having said that, when we look at the breadth and the scope of these decisions, right, the idea that the former president of the United States is immune from criminal prosecution for a broad swath of their activity, not just their core constitutional responsibilities, things that they were always and obviously immune from, but they obviously can't be criminally prosecuted for vetoing a law, for instance, right? But for all kinds of conduct at the periphery of their office, including, for instance, exploring with a subordinate official at the Department of Justice how to overturn the results of an election, and to do so in ways that seem to involve both lies and frauds. Fraud. It's just, I think, stunning to digest how much of an earthquake in constitutional law, and how much of a redistribution of power away from Congress and into the court and the presidency that one decision represents. Congress, up until this decision, believed it had the authority to restrain the president by passing laws that had criminal sanctions, and the court has just said, no, you don't. Right. And so the result is a fundamental shift. And I want to say, as I said last week, an undermining of the very idea so central to, again, the narrative that we sustain as our story of civic identity, that we are a country founded on the rule of law, and that we have created institutions that check and balance and separate power in order to sustain the rule of law. This decision fundamentally calls that narrative, that collective commitment into accomplishment. I'm sorry, into question. I'm looking at the next thing I want to talk about, the January 6th obstruction charges having been overturned. I just read the language of the statute in preparing of this, and this decision, which I was agnostic about, and obviously this was a somewhat split decision, but or split in different ways than we're used to. But having said that, it just seems very peculiar to me that the idea that invading Congress to disrupt the um, counting of the Electoral College. There's a peculiar arcane dispute in this case about the meaning of otherwise, but it seems that the court really had to twist the meaning of that term, and the result is that perhaps a fair number of the people who invaded the Congress will have convictions overturned. The power of federal agencies, and in particular of the administrative state, the way in which, as I've put it before, we grafted a 20th century administrative state into an 18th century constitution, that has been undone. I'll say more about this as we get into it, and we can keep going. Very important decisions on guns, very important decisions on racial gerrymandering, stuff that's not even on the diagram here, to do with the statute of limitations and under which corporations can challenge administrative regulations, essentially making it possible to forever challenge those regulations. And of course, at the very beginning of the term, the decision that essentially voids one of the key articles, Section 3 of the 14th Amendment, which prohibits insurrectionists from serving in the major offices of the United States. Again, these are hugely consequential decisions. Before getting into let me actually for a moment get into the details, just to look at the sweep of these decisions. So, right, shifting the power within the federal government decisively in favor of the executive, diminishing the administrative state and with it the capacity of the federal government to impose a whole bunch of regulations. I think especially as we brace on the East Coast for a heat wave, maybe environmental regulations would be the most important of these to be overturned. And then if we extend our purview to include not just this term, but the last three terms, overturning Roe v. Wade, ending affirmative action, an incredibly originalist decision on guns, and then that was all right, New York v. Bruin a couple years ago, but the Garland v. Cargill, the bump stock case, right? The direction of the court so clearly adverse to what Congress has been doing on guns, what the Trump administration did on guns. I want to suggest that this is a rogue court, that this is a court that is now clearly behaving like a partisan institution, doing what Congress has been incapable or unwilling of doing because, of course, the American people are split on and, in many respects, very critical of most of the aspects of this agenda. The court is now saying, we will take over on each of these policy issues. We will make the law that Congress will not, cannot, does not want to make. And so this is right a partisan approach, and I worry in particular that this is in certain respects a constitutional coup. It is a group, and when I say this, let me be as clear as possible what I mean by this. I'll get into this a little bit further in just a moment, but a group of justices who represent a party, all of them appointed by a party, right, that has won exactly one presidential election in terms of the popular vote in the entirety of the 21st century, right? And the one time a president won the popular vote, it's only a president who was elected despite losing the popular vote in the previous round, right? So the idea that this court might have some modesty, might have some humility, might recognize we do not carry the legitimacy and authority of having been appointed by presidents who won the majority popular vote. Similarly, they have been confirmed by a Senate that in several instances have engaged in acrobatic efforts to alter the composition of the court, and a Senate that vastly overrepresents the power of a relatively small minority of our population because of the principle of equal representation of all states and the vast disproportion in population of our states. When I say a coup, what I am suggesting is that this court clearly represents the views of a small minority of the American people. And having said that, the fact that the Constitution is made in the name of we the people of the United States, when a relatively small minority uses the way in which the institutions of our Constitution exaggerate their influence to impose their will, their interpretation, not just on the Constitution, but on all these areas of American politics, it begins to feel as if there is an institution that has no electoral accountability, that the members of which serve lifetime appointments, many of whom have been appointed by the minority power in our society, that are hijacking our institutions and our politics and using them to their ends, despite the fact that they are supposed to be the people's principles in interpreting the Constitution. So that's why I speak in the title and in point 6 on the slides of a constitutional coup, and I want to be as clear as possible. This court is supremacist. It denies, right, the authority of the people of the United States to interpret their own Constitution. It denies the power of the accountable branches of government, of Congress and of the presidency, to say what the Constitution means, as opposed to a dispersed view in which the Supreme Court has its views, but it has to negotiate its views with the Congress and the president, who are more accountable and hopefully representative of the people. This court says no, right? Alito's opinion in Dobbs was very clear about this. We are the only ones who have the authority to say what the Constitution means, and we are not going to respond to or bow to the views of the people or the institutions that represent them. Originalism of convenience. And here I want to be as clear as possible. Again, the Trump v. US case doesn't have a gram of originalism in it, right? It is not at all concerned with the history of the Constitution or the understanding of the founders, but the Bruin and Garland cases, the gun right cases, are wholly originalist, right? So which justice in the 6-member supermajority of conservative justices writes a decision, in part determines whether or not it's going to be an originalist decision, but in part it seems that on certain issues they're going to be highly originalist, and on other issues they're going to be unconstrained by tradition. But the idea of originalism, I want to suggest, is really important to understanding this court because it is an intrinsically conservative, and I also want to suggest intrinsically incoherent mechanism for interpreting the Constitution. Finally, maximalist in the sense that this is a court that wants to use its power to the maximal degree to change the way in which the Constitution is interpreted, and not only that, the policies and laws of the country, for instance, beginning to dismantle the administrative state when Congress and the president won't do that, right? And so I have questions here that I started asking a couple years ago in the aftermath of the overturning of Dobbs. How far will this court go in reversing the law created by predecessor courts, and how fast? And I think we're beginning to see the answer to that question. It is trying to fundamentally turn back the clock on broad swaths of American constitutional law, and it is in a hurry to do so. What will the repercussions of these decisions be? Will they further consolidate the ability of a minority of the American population to impose its will on a majority? And I want to say the outcome of the 2024 election, the outcome of the election for the presidency and for the Senate seem to be incredibly important in determining this, right? And I'll let me see, go back for a moment. I will just note, right, and I think you know the way this works. The older justices, the longer serving justices sit in the front. The newer justices, the younger justices stand in the back. We have here in Alito, in Thomas, in Roberts, several quite old jurists, right? And they appear to be in relatively robust health. But having said that, there's a good chance, and I think we would add Sotomayor in particular to the group that over the next 4 years, there's a possibility that 1 or 2 or 3 of those justices come off the court. Will they be replaced by a Democrat? I'm sorry, an appointee by a Democratic president, or by Donald Trump, right? And to be as clear as possible, right? Donald Trump put on this court the 3 new justices who have fundamentally changed the direction of this court. If he has 1 or 2 or 3 more appointees, if he puts on younger people and perhaps even more radical people than those already appointed, this could then have incredibly important long-term ramifications on constitutional law and politics that could take us all the way into the 2050s. Will these decisions undermine the rule of law, exacerbate polarization, weaken American democracy? I think the answer to this is now relatively clear. And the answer is, unfortunately, yes, right? That we are going to see a former president of the United States who tried to overturn the outcome of a presidential election, essentially not held to account for that via a jury of his peers, perhaps ever, certainly not before the next election. So before jumping into the details of the 23-24 term, I want to spend a few minutes building some context from which to consider this term. And as you know, I have introduced you before to the writings of Bruce Ackerman, and in particular to his seminal 3-volume study of the history of American constitutional law, which goes under the title We the People. And in just a moment, you'll see why Ackerman chose that title. And the issue here, and what I want to put in place for you, is an interpretation of the last 100 years of constitutional law up until maybe 10 years ago, in which the Constitution has in fact been transformed, transformed by the court in concert with the president and Congress, that these three institutions were moving in the middle of the 20th century in harmony to increase the rights of women to the point where they could count as full equals in our society, to increase the protection of the rights of African Americans to the point where they too could come out from under Jim Crow oppression and become full and equal citizens, to allow an administrative state to grow out of the institutional structure of our 18th century Constitution, and in so doing to vastly increase the power of our federal government to regulate our increasingly complex and articulated economy. And I could keep going, right, in terms of, right, the treatment of gender and sexuality, etc. But this is a clear transformation of the Constitution that occurred over the last 100 years. And I believe in informing the Roberts Court, informing its, as I've said, supremacist, originalist, maximalist approach, is the view that this was all a court-directed coup. The reason they are justified in bringing about a counter coup is because none of this was legitimate to begin with, and they need to return us to where we were 50, 80, 100 years ago in order to restore what was the original legitimate constitutional order. And the reason I point to Ackerman, the reason I'm going to rely for the next few minutes on his ideas, is he gives us an alternative understanding. If this is just whoever has the majority of the court does with it what they want, and that the Constitution is the plaything of the ideas of the justices on the court at any given time, then we can be very critical of what the Roberts Court is doing because we don't like it and we don't want them to do what they're doing, but we may be a bit hypocritical if we start calling them illegitimate, but we're very happy with what the Warren Court did, for instance. And how can we differentiate what the Warren Court did from what the Roberts Court is doing, other than in saying we like what the Warren Court did, we like Brown v. Board of Education, and we dislike what the Roberts Court is doing. We dislike Trump v. the U.S. and Dobbs. And here, what Bruce Ackerman helps us to see is an alternative theory for why it is at points legitimate for the Supreme Court to alter the meaning of the Constitution via interpreting it differently, and why that exercise of constitutional authority by the court can be judged by the people to be either legitimate or illegitimate, as opposed to just whichever way the court wants to take it, that's what it gets to do. So Ackerman takes seriously the idea of John Locke's that there is fundamental popular sovereignty over the highest law of the land. That law is called the Constitution, and it is the highest exercise of popular sovereignty. The people are not sovereign if they don't have sovereignty over their Constitution. And Ackerman suggests that the framers of our Constitution understood this idea and incorporated it into the Constitution in the preamble by speaking in the name of we, the people of the United States of America, and through the ratification procedure, which allowed the people of each state the sovereignty to accept or reject the highest order law that was being made in their name. And that it is one thing to make a new constitution in the name of the people and allow them the power to ratify it. It's another thing to preserve popular constitutional sovereignty over a period of of centuries. And so Ackerman asks, how have we done this? And he suggests the Constitution gave us a mechanism. That mechanism is constitutional amendment, but it turns out that that mechanism is very difficult to use. And so the fact that we've amended the Constitution fewer than 30 times over the course of a couple centuries, I think indicates not only or not primarily that we got it all right, and so we haven't needed to change very much, but just how difficult the procedure in the Constitution for amending the Constitution is. It's far more difficult. It requires more stages and more super majorities, more exacting thresholds of justification than any other democratic constitution in the world. And that we have, as a result, improvised other mechanisms for changing the interpretation and the meaning of the Constitution, and here in particular, the idea of an institutionally dispersed, ongoing project of maintaining continuous popular sovereignty in constitutional politics is a powerful lens through which to read American history. And again, I want to emphasize here that our identity as a people is a narrative accomplishment that we have expressed in our founding documents, in the Declaration of Independence, in the Constitution, in the amendments to the Constitution, and the civic acts that express our deepest self-understanding, Lincoln's Gettysburg Address, some of the Supreme Court cases, the 14th Amendment, that in these constitutive aspects of our identity, we have expressed this idea that we, the people, are sovereign over our Constitution, that we view it as a progressive document, to quote again, this time from the Constitution's preamble, right? We aim to form a more perfect union. We know we didn't get it all right from the outset. How do we do this? Well, we do it in part by amending the Constitution, but in part by passing laws that slowly over time change the meaning of our Constitution, and through Supreme Court decisions that slowly modify the interpretation of the Constitution. And what Ackerman says is that in the history, the 200 plus years of this document, really we have had not one, but three constitutions, maybe four constitutions. We've had the Framers' Constitution from the ratification through the end of the Civil War, which was an exclusive constitution. It accommodated slavery, it disenfranchised women, it permitted property qualifications, and it was a product of populist mistrust coming out of the period after the conclusion of the civil the Revolutionary War created this strong sense of popular sovereignty. The founders aimed to rein that back in, to demobilize us a little bit, to get us out of the streets and into normal institutional channels. And having said that, right, the people contested this and used, right, an era of popular constitution in which they clearly said, this is our constitution. We fought a revolutionary war in order to gain the power to write it. We're not going to relinquish that power over to courts or elites. And so this idea of dispersed interpretive authority to remake the Constitution was alive and well, even as the Constitution itself was in this period a slave charter, an instrument for disenfranchising women, and for part of its history, at least, for disenfranchising those who didn't have sufficient wealth. But we then have the Civil War. We then have multiple amendments to the Constitution, including critically the 14th Amendment that abolishes slavery and protects the equality of citizens under the law as any person natural born in our society. We have in the middle of this Plessy v. Ferguson, which accommodates Jim Crow, the Lochner era, which makes the New Deal very difficult and elevates private economic rights. We then get the 19th Amendment, which gives women the right to vote. But having said all of that, right, we then have a second constitutional revolution, which really starts with the New Deal, with the end of the Lochner Court. I'll say just a little bit about this because I think it's the best illustration of what Ackerman is talking about, right? And so the election of Franklin Delano Roosevelt and the New Deal Democrats to supermajorities in both houses of Congress allows the Democrats to start creating the administrative state, right? And so the Security and Exchange Commission, for instance, let's never have another Great Depression caused by runaway speculation and fraud on Wall Street. Instead, let's have the federal government regulate this kind of economic activity. And in order to do that, we need to create an administrative agency that is staffed with civil servants with specific expertise in security law and the current trends in the economy and the stock exchange. And Congress needs to empower them to devise regulations that shift more rapidly and are more nuanced than the kind of law Congress can make. Congress is not populated with those kinds of experts, right? And so we get this new institution, and then the Supreme Court which has elevated private economic rights, knocking it down. And we get this back and forth in which the Democrats keep winning elections, keep passing legislation. And by the way, when the court invalidates the legislation, the Democrats, the members of Congress, the president do not consider that to be the end of the story. Rather, they pass more or less the same legislation or legislation that has the same institutional and constitutional implications again and again. And as the court keeps knocking it down, FDR launches the plot to reconstitute the Supreme Court. It's actually a little bit more complicated, it turns out, than just appointing 6 justices. But having said that, court packing leads rather quickly to the Supreme Court to abandon its nullification of the New Deal legislation and to change its interpretation of the Constitution. And so there has been a contest between the different branches of the government over what the Constitution permits. And the Supreme Court has come to recognize that the people of the United States, the ultimate sovereign over the Constitution, have an interpretation of the Constitution and what it allows that differs from the court's interpretation, and that the court ultimately has to concede the highest order sovereignty and authority of the people in interpreting the Constitution and get out of the way of the New Deal, right? And so there's an example of the Constitution changing its meaning, not because an amendment was passed, but because of a contest in which the people asserted, we now understand our Constitution to permit the following, and that is what we want our government to do. And that suggestion, right? And by the way, we then get the New Deal, we then get the rights revolution as well, in which women and African Americans and others get much more expansive rights protected by the Constitution and the courts in order to make them full equals, right? This is the really important jurisprudence of the Warren Court. But having said that, at the same time that the Warren Court fundamentally continues to transform our Constitution in ways that I think were more or less consonant with what a majority of Americans wanted to see. I think it's a little difficult to precisely demonstrate that claim, so I will concede that at points the Warren Court and the courts of the middle of the 20th century may have been ahead of what the people wanted, and so began to exercise a kind of supremacist authority to say, we, the court, know what the people want, and we are not going to slow down if the Congress or the president get in our way. We don't recognize dispersed authority to interpret the Constitution. That is an element that begins to creep into the constitutional law of the second half of the 20th century. And this is what leads, right, the Roberts Court to think that all of this jurisprudence is illegitimate. And I want to be as clear as possible. I don't think there's any way to establish a clear, bright dividing line between when the court does what the people want it to do and when it is acting on the basis of an interpretation of the Constitution that doesn't have clear, stable majority support from the sovereign people, other than to let the politics play itself out. But what is clear in poll after poll, election after election, is that the direction that the Roberts Court is taking our Constitution in is not one that most of the people of the United States embrace. And here, the idea that they're just doing what the Warren Court did, what earlier 20th century courts did, but they're doing it in the opposite direction, and they have the majority now, so they get to do it, is, I think, highly important to understanding why they discount the objections of the president, of the Congress, of the people of the United States. And so, as opposed to saying, right, this is just what's good for the goose is good for the gander. The Warren Court had the majority, it gets to do what it wants. The Roberts Court has the majority, it gets to do what it wants. There is a principled constitutional argument to be made that the Roberts Court is performing a coup and that we should resist it. And so I hope this is clear. I know I went into some tangled jurisprudence here for a few minutes, but that there is a difference between the people of the United States changing its mind about what the Constitution means and the court changing its mind. And to be as clear as possible, I do think that there is a principled agreement between much of the MAGA wing of the Republican Party, which now refers to itself as Christian nationalist, and much of the majority of the Roberts Court, right? And the principled agreement is on the idea that the country made a mistake when we became more multicultural, less traditional, more diverse, allowed greater power into the administrative state, etc. And that the court needs now to correct course. And if that is the view of a stable majority of Americans, then the court is justified and legitimate in the kind of jurisprudence we've just been looking at, the decisions of the last 3 years. But I do not believe, and I'm actually certain that the election results, the polling results, the direction of public opinion in the United States does not warrant that conclusion. And in that sense, the court, I believe, is confusing what is a powerful minority movement, which may very well put Donald Trump back in the White House, may very well give a majority in the Senate to the Republicans, but do so on the basis of having lost the majority vote in both of those institutions. That does not represent an expression of popular constitutional authority. That is not a good basis to radically and rapidly remake constitutional law. And so I want to suggest that the Roberts Court's misunderstanding of the people and the basis for what it's doing threatens to undermine the legitimacy of the Supreme Court, and with it, of the institutions that sustain the rule of law and the solidity and security of constitutional rights in the United States. I'm obviously not going to get into all of the decisions today. We will take a tour of some of the most important decisions next week, assuming nothing extremely urgent occurs in the news over the next week. We are obviously looking forward, among other things, to the Republican National Convention. We'll have that to talk about next week, but we will also continue to talk about what happened in the court. Who wants to start us out with a question or a comment for today? Flossie, are you trying to speak? You have to unmute yourself. Go ahead.
Can you hear me now?
I can hear you now. Go ahead.
Just a light moment. I've been surfing the web, you might say, and listening um, to a lot of people who are passionate about Biden, but don't know what to do about it. They list all his accomplishments, and they are enormous. He got us through a terrible period in our history. I'm not talking about COVID alone, but everything that was thrust at him. He has this quality, he may not be the smartest guy in the world, but he knows who's smarter than he is. And that's a good thing, especially in an older person. But what I heard at one moment was just delicious. One guy who was determined to get Biden back in office said, I would vote for Biden even if he were dead. I think that's a wonderful recommendation. I leave.
Thank you, Flossie. And there's a piece by Robert Kuttner online. And I'm trying to remember the title, but I think it's When Dead Men Win Elections. And this happens right on a fairly regular basis in American politics, where a candidate dies weeks before the election. It's too late to get them off the ballot to replace them, and they end up winning the election. And Kuttner's point was, a la Biden, that it would be better to have Biden dead than Trump alive in the White House. And you may have seen Thomas Friedman, I thought, had a nice line in a recent op-ed in the Times in which he said, if Biden wins, we have to hope he's able to get out of bed. If Trump wins, we have to hope he stays in bed, right? And so yeah, there's some levity and some fun to be had with this. And I guess one of the questions here is, look, Joe Biden clearly has appointed a highly capable administration, and of course, a large part of the functioning of the executive branch comes down to what the people the president appoints do, and his direction and delegation of authority to them. And Biden has been very capable in both of those respects. But on the other hand, we also need presidents capable of managing crises. And crises occur, it's the nature of a crisis, of course, in unanticipated, unexpected times. And is Joe Biden going to be up to the task if there's some event in the South China Sea that threatens to escalate into a war between the United States and China? And here I'll pivot to a second aspect of the presidency. A president needs to be an effective communicator, also needs to be someone who invokes a kind of authority, hopefully allows us to feel a certain unity in moments of crisis. And by the way, needs to be able to win elections in part by defeating a dangerous opponent by exposing them as such. And if Biden can't effectively communicate, can't effectively campaign, can't effectively debate, and may not be able to effectively manage a crisis, I do think that realism demands that we weigh all of that. And that doesn't mean that there's a great path forward, right? Sometimes we end up down paths we never should have taken. We should really have figured that out 6 months ago, that we needed to change course, not today in the middle of July. But having said that, that doesn't obviate the need to try to figure out, is there a better alternative? If there's none, then maybe we need to vote for Biden even if he's dead. But having said that, let us spend the next couple of weeks really carefully trying to figure out if maybe there's a path beyond voting for Joe Biden when he doesn't seem to have the full array of skills that we would want from an effective president. That's my position right now. And I know there will be people who say, stop beating up Biden. Look at how bad Trump is and focus there. But the truth of the matter is, even if I do that, that isn't going to change the fact that a large portion of the voters who Joe Biden needs to win to become president of the United States are maintaining that Joe Biden is too old and that they are probably not going to vote for him. For that reason, we might castigate their bad judgment, right? Better dead Biden than living Trump. But having said that, if they're not going to vote that way, not going to be able probably to convince them to vote that way. We need to take that into account. Thank you, Flossie. I know you tried to get us to something funny. Of course, I took it in a serious direction, but that's my bent. David, you've got your hand up. Go ahead.
Let me just make sure that I'm
You are
not. Yeah, I'm unmuted. Well, I was going to say what I found intriguing about your lecture today and focusing on the court is it reminded me of what's the Heritage Foundation's project, something 2025.
Project
It seems to me,
2025. Yes.
yeah, it seems to me that that's consistent with what the court is engaged in. And so it's not just the court, it's also a cultural project. And I think it was Heather Cox Richardson's column a day or two ago suggested that this whole movement, the court, the politics, the legislative agenda, is all intended to return us to an American culture that was prevalent. And I don't remember whether it was pre-Eisenhower or pre-Roosevelt, but to go back to the good old days, and that's really the overall project. But clearly, the court has probably the major role in it right now. But at some point, there might be a legislative and, of course, a social movement to enhance this same direction.
Thank you, David. And I think I probably read the column you're referring to, or the Substack. And I'll be brief about this for now because I have a whole bunch that I want to talk with you about in terms of next week. But let me just preview this, and I've spoken a little bit about this before. But the idea of reimposing tradition on a society that no longer voluntarily or organically maintains that tradition, right? And so going back to Eisenhower or Hoover's America, I think refers to going back to an America that was 90% Christian as opposed to less than 2/3 Christian, going back to an America in which children followed the traditions of their parents by maintaining the religion of their parents, right? This is the core of Christian nationalism, going back to a country that had clearer gender roles and norms that clearly enforced a gendered division of labor in society and within the family and made it clear where men and women belonged and didn't belong, right? That these are some of the elements of this. And please note then, and this is where Project 2025 and the Supreme Court's effort to redistribute power from Congress and into the executive come in. Unlike in the 1920s, 30s, or 50s, when people are voluntarily reproducing tradition. If what we have to do in the 21st century, if we're going to be more traditional, more Christian society, is coercively impose tradition on people, we need a state strong enough to impose tradition on the population, right? And here, Congress, the way it's constituted, its very nature, right, represents the full diversity of the United States and demands that its members deliberate and compromise so as to hash out our differences. That's not an institution that is going to take an increasingly unpopular tradition and coercively impose it on the large portion of the population that rejects the authority, the validity, the attractiveness of that tradition. So where do you get the power to impose the tradition? Through an enhanced executive. We call it a strong man in European politics. And it does appear that Project 2025, which takes Viktor Orban as the model for Christian democracy or illiberal democracy, is outlining a second Trump term in which the president has and uses the power to turn back the clock on American culture and norms, and that the Supreme Court is getting in line and trying to empower the president to do this. I have to say, I think this is magical thinking of the highest degree, right? Yes, you can take away women's abortion rights, and maybe you can even try to criminalize the transmission of the abortion pill across state lines. But in the 21st century, women are going to figure out how to get access to these pills, right? And we would have to be an incredibly authoritarian society to force people to have children, right? Please note this is what Viktor Orban is talking about, what Heather Cox Richardson is calling our attention to, this idea that part of the problem is that Christians are not having enough children, that white people are not having enough children. You're going to have a civil war on your hand if you really try to use the presidency to reverse that. So yeah, this is a way of expressing your moral panic over the way in which a large portion of your population is going, but it's not a realistic policy for changing that direction. That doesn't mean that this won't be incredibly dangerous, incredibly divisive, and a really difficult period for civil rights in the United States. But I don't think it's a recipe for success, and that it's bound to produce a spectacular failure. Sometimes the course to progress has to move through periods in which we're convulsed by crisis. And I would much rather avoid that. But that seems to me the direction the Republican Party and the majority of the Supreme Court are pushing our country in right now. Thank you, David. Obviously, I'm productive. I'm thinking about this stuff as well.
Right.
Anybody else for today? Be well. Keep your chins up. Keep looking for the funny stuff. We'll come back and talk about this more together next week. Thank you, everybody. Take care. See you next week. Bye, guys.